Can you please report, my lady, I do appear on behalf of the first respondent, together with my senior, Donald Wolf, who unfortunately is not able to attend today's hearing, and I will be standing in for the matter. I am also briefed by Zuma Incorporated attorneys.
Zuma Incorporated. I've just been looking to see whether your heads of argument are here. Good, thank you. Mr. Shitanda?
As a floor, please. My ladyship, I believe we've got two sets of heads of argument.
Yes, that's correct.
The applicants will just deal with what I believe are the most important points within my heads of argument, and then stress the essentials regarding the terms that we need to satisfy the requirements of the interdict. And my heads do mention that if successful, the applicants would like to file a replying affidavit if an interim order is granted today, and my ladyship is satisfied.
So you have to speak up, Mr. Shitanda.
I said, my lady, if the court is satisfied and we do reach the threshold for interim interdict this morning or today, the applicants would then be in a position to file a replying affidavit ahead of a...
But is the matter ripe for hearing if the replying affidavit hasn't been filed?
At this point, I believe it is. We can move, the applicants want to move on the basis of the papers that are before this court.
All right.
My lady, the respondents have, the first respondent disputes jurisdiction. Again, the second respondent, the Speaker of Parliament, has filed a notice to abide, and they have got no argument against the relief before your ladyship. The jurisdiction, the respondents are claiming that, look, the decisions that are before this court in the review application were made in Nkanda and not within the area of this court's jurisdiction. And the submissions that the applicant would like to make in that regard is that the MK party, like all other parties within the National Assembly, have a presence, have offices within this court's jurisdiction in the National Assembly. And those offices are within this court's jurisdiction, and on that basis, in terms of Section 2.1 of the Superior Courts Act, this court does have jurisdiction to hear this matter. In regards to locus standi, one of the issues that the most important issue, I'd say.
Has urgency been agreed? Has it been agreed that the matter must be heard as an urgent application?
When the matter was brought before Judge Erasmus, Judge Erasmus did set this matter, or postpone it to today. And he did so on the basis that, he understood that it was urgent, even though he didn't expressly, I think he might have mentioned it in the hearing. But he did not, he said that that's something that you have to deal with then. But the urgency, my lady, has not been agreed. And the respondents are arguing that the matter is not urgent for the reasons set out in the heads. But I'll get to that. What I'd like to do is just deal with jurisdiction first, then, which I think I already have, and it's been dealt with in more detail than I've mentioned on my feet, in my heads. Then locus standi, urgency, and I'll go through the merits of the incident. In regards to locus standi, I couldn't understand the respondents' dispute or their argument for locus standi. Obviously the applicants are acting in their own interest. They're seeking relief for themselves and for their dependents. But I think what I'll do is just deal with what former President Zuma's submissions were in his answering papers. He says at paragraph 22, absent any allegation of membership of the MK, the applicants have no standing to seek the relief directed at the MK. It must therefore be released from this application. My lady, the founding affidavit in the review application in paragraph 9 makes it very clear. In fact, they do say, all of the applicants, they said that...
But don't you need to use Plascon evidence to resolve disputes of fact in motion proceedings? This is why there's no reply. We must determine the matter on the basis of the rules set out in Plascon evidence.
Yes, my lady, but just
so
based...
what do I do with a factual dispute like that?
Well, the founding affidavit says that there are.
So what I'm saying is on Plascon Evans, how are you asking the court to deal with the issue? You've got the founding affidavit that says we're members, and you've got the answering affidavit which says that you're not.
But what we do have is the answering affidavit saying two different things. The answering affidavit, former President Zuma's answering affidavit, says two different things. He says that they were never members of the MK party. And then he also says, I'm going to get to that, he also says that he used his powers to remove them. You cannot remove people that are not members of your party to begin with. So his own answering affidavit, in that respect, it makes out the case that the applicants require in regards to the locus standi. I'll get to that in more detail, but he does say, in fact, I mean, in the paragraph in my heads that where I discuss the discretion of this honourable court, I do mention that, and I like to, I mean, I've got no other way but to use strong language, the deception of that answering affidavit. He says they were never members of my party, and the same papers, I got rid of them. And on that basis, my lady, I think it's pretty clear that the answering affidavit does set out that the applicants were indeed members of the MK party without a replying affidavit to dispute that. And the Plascon evidence rule does say that the answering papers, if they're far-fetched, and obviously this matter, on that point particularly, they are far-fetched. He's cancelling his own argument out. My lady, that is the case for at least the locus standi. Section 38 obviously of the Constitution does provide anyone acting in their own interest, as these applicants are, to approach this court for relief. In regards to urgency, my lady, there is no agreement for urgency. The challenge, I assume, and just by looking at the respondents' heads of argument I received this morning, is the time that is preceded for us to be here, or at least preceded for the first hearing before Judge Erasmus. We have a letter from Mr. Jenkins, the senior parliamentary advisor, where he says the position of the National Assembly, the position of the Speaker. That letter makes it very clear that this matter is urgent. Just for the sake of not just the record that's already in the heads, but to assist me in making the argument, I'd like to read out.
What page of the record is this?
My heads of argument, it's page 6, but in the record it's page 6 of my heads of argument.
It's the letter of the 19th of August.
19th of August letter from Mr. Jenkins. And I believe that letter is page 5 of the founding affidavit. It reads, your correspondence dated 19 August 2024, which we acknowledge receipt bears reference.
But where's the correspondence?
The correspondence is attached TF2 of the founding affidavit.
Is at which? So what page of the record?
Page 15.
15.
Yeah.
15 of the record.
15 of the record, and...
But that's... Oh, I see, yeah.
Yeah, there's 15 of them.
Thank you.
Your correspondence dated 19 August, of which we acknowledge receipt bears reference. The administering of the oath or solemn affirmation by the Speaker of the National Assembly is a constitutional obligation required by Section 48, read with Item 4.2 of Schedule 2 of the Constitution. Section 237 of the Constitution provides that all constitutional obligations must be performed diligently and without delay. Given that your clients are challenging their expulsion from the political party, they should interdict the party from fulfilling the positions, and interdict the Speaker from administering the oath or solemn affirmation of candidates that would be nominated by the party to fill the positions. Without an interdict, there is no legal impediment of the nomination of the new members, and the Speaker must proceed with the administration of oath or solemn affirmation so as to give effect to her constitutional obligations. We would like to add that the Speaker will not be administrating the oath or solemn affirmation of candidates tomorrow at 20 August 2024.
Have the positions been filled, Mr. Chitando?
No, the positions have not been filled. My lady, what I understand, and the papers that have been presented were filed before some, I believe there were some appointments made last week. This is not in evidence, but the positions have not been filled. There are 18 expulsions and 8 positions have been filled, which mean that the 10, the respondents like to call them the group of 10. I will use that in argument as well, as this makes it easier to explain. That group of 10, those positions have not yet been filled. So from the Speaker's correspondence, it is clear that she's informed the applicants that there's a pressing requirement for them to apply for to get an interdict if they would like to assert their rights. That's what we had, and this was communication. The applicants are going to rely on the judgment by Plaskett J in Nelson Mandela Metropolitan versus, I can't pronounce that, I'll just call it Nelson Metropolitan Municipality case, where it was found that an applicant who seeks from the respondent before lodging an urgent application, seeks compliance from the respondent before lodging an urgent application, cannot be said that they were dilatory in bringing the application or that urgency was self-created. The applicants, and it's made out in the sequence of events coming before this court, they did send communication to the MK party. They did send communication to the Speaker. That communication was not responded to, and they came to court. The date in the correspondence that Mr. Jenkins and the Speaker mentions, in the last line of Annexure TF2, that we would like to add that the Speaker will not be administrating the oath of the candidates on 20 August 2024. That date was, there was a rumor that was circulating, and in the correspondence they did say, look, we hear that you're going to swear in our replacements on that date. We are going to go to court urgently to stop that. And that is important, my lady, because it shows that the applicants are not sitting on their hands. They're moving quickly. After they got the rumor that there was something was going to take place, on the 20th, and obviously their communications to the Speaker and to the MK party went unanswered. That is that is obviously, that letter is a compelling argument for approaching the court on an urgent basis, considering that before that also a review application was filed, which is subject of this urgent. The respondents call it Part A and Part B, but there's actually two separate applications. So that review application was filed before coming to urgent court, and without an interim interdict this morning. There's nothing to stop the respondents from simply filling the positions before the applicants have had an opportunity to have their review application considered by this court. My lady, I'm now going to move very quickly. I know we have pressed for time. On the requirements, the threshold for an interim interdict that the applicants must canvass and must persuade this court on. The first requirement being that of a prima facie right. Considering that we've got three prayers that the applicant would like to make orders of court. The first two, I would like to call them the review prayers. The review prayers. And I would have to satisfy this court that the applicants have a prima facie right on those two prayers. Just for the sake of reminder, the review prayers are prohibiting the second respondent from administering the oath or solemn declaration of any candidate put forward by the first respondent to replace the applicant's membership of the National Assembly pending the outcome of the review application before this court under case number 18079 of 2024. Two, prohibiting the respondents from denying the applicants any and all benefits of membership, including the parliamentary accommodation pending the outcome of that review application. And, my lady, go into the prima facie right to these two prayers. The most important fact, I just mentioned it when we're dealing with when my lady was asking me about the replying affidavit and the dispute in regards to local standing. My lady, the applicants in the review application, they claim that, and I quote, they are members of the MK party sworn in as members of the National Assembly on 22 June 2024. We joined the party and the National Assembly after assurances were made that the party was democratic and would be governed in a manner consistent with the Constitution of South Africa and the rule of law. That is what they say in the review application. And obviously it's the right, their prima facie right is based on the strength of that review application that's before this court. My lady, I go into the heads of argument goes into